I'm going to speak about the Civil Contingencies Act 2004 as it relates to the current coronavirus emergency. Now, the Civil Contingencies Act defines emergency very widely indeed in sections 1 and 19. And the outbreak of the novel coronavirus in the UK plainly falls within these definitions. So section 19 refers to a situation which threatens serious damage to human welfare in the United Kingdom. That's section 19(1)(a). I need hardly tell you how clear it is that situation pertains today. The existence of this emergency empowers the making of orders in council. That's technically orders by the Queen with the Privy Council under section 20 of the Act. That is, by making emergency regulations which are required to control or mitigate the effects of the emergency where necessary. I should note as well that the Civil Contingencies Act doesn't include any concept of a state of emergency, which is why the United Kingdom, unlike other countries, has not declared a state of emergency or a national emergency, although both clearly pertain today. If the emergency in question leaves no time or opportunity to assemble the Privy Council, then the emergency regulations can be made by way of statutory instrument by either the Prime Minister, a Cabinet Minister, or one of the Commissioners of Her Majesty's Treasury. Emergency regulations can make as far-reaching provision as could be made by an Act of Parliament. But those regulations cannot amend the Human Rights Act. They can't amend their own enabling provisions in the Civil Contingencies Act. They can't introduce military conscription. They can't ban industrial action. And they can't create any criminal offences other than for disobedience connected with the regulations themselves. But subject to these limitations, they can amend or disapply almost any laws. Such regulations may be draconian in effect. They can provide for the confiscation or destruction of any property without any compensation. They can force people to relocate, and they can prohibit their assembly. The regulations may criminalise disobedience to their effect, with up to 3 months imprisonment available on conviction in the magistrates' court. And nothing whatsoever stops these regulations creating the necessary police powers, so long as those powers are Human Rights Act compliant. And equally, nothing stops these regulations, more significantly, conferring police powers or quasi-police powers on others. Let me turn to democratic scrutiny of emergency legislation. These regulations can last up to 30 days, but they can be renewed, if necessary, repeatedly. That's section 26 of the Act. But a senior minister must, as soon as is reasonably practicable, lay the regulations before Parliament for scrutiny. And then if each House so resolves that the regulations can either be annulled or amended, or if each House does not approve the regulations within 7 days of it being put before them, the regulations automatically lapse. And so it's the laying of the regulations before Parliament that starts the validity clock running. The regulations, if annulled, can be renewed by the Privy Council or by ministers. That's section 27(4)(a). So what if draconian regulations were made and ministers dragged their feet or were not able to lay them before Parliament? For example, if Parliament were unable to meet because of the current coronavirus emergency in order to make set the validity clock running. Well, in that case, the High Court and the Court of Session will have power to strike them down. For example, if the threshold conditions are not made out, or to the extent that they are incompatible with a human right. Of course, they are to be read insofar as they can be, so as to be compatible with the Convention rights. And if such regulations are quashed, it may leave those who have exercised powers and duties under them, such as the police, highly vulnerable to challenge. Now, I envisage that emergency regulations in the current emergency may be made in two main areas. First, where there's a serious breakdown in law and order and or serious deterioration in the health of the nation, necessitating strong controls over gatherings, curfews, the purchase of necessities, etc. And second, where stronger healthcare interventions were required. For example, where there was a need on medical advice for mass compulsory testing of individuals, including for antibodies, i.e. immunity to the coronavirus, or a compulsory vaccination program. So the current testing powers criminalise non-cooperation, but they do not permit the use of force to enable testing to be done against a person's will. Now, such compulsory testing or mass compulsory testing and vaccination is more likely to be achieved by ordinary legislation than by emergency legislation for perhaps obvious reasons. What's the position of the police? Well, the police will find themselves, likely as not, on the front line in the enforcement of emergency regulations, especially those that relate to curfews, the prevention of looting, such as might occur if there's a breakdown in civil society. The regulations may purport to create additional police powers to give directions or orders in order to enforce curfews or relocation orders. Now, it's highly likely that the burden of enforcement, including requisitioning property, for example, will fall very heavily on the police, potentially assisted by the armed forces. And one can again envisage property being requisitioned for use as either isolation units or hospitals, or, it's sad to say, morgues. It's possible that emergency regulations will create a special scheme for review of the exercise of emergency powers to be conducted swiftly by a specially established emergency tribunal. In that connection, see section 22(3)(n). Maybe such a tribunal would be the body that decided on whether property was to be appropriated or expropriated, or whether individuals or classes of individuals were to be relocated in the country or to particular locations. So the police will need to understand and ensure they understand the precise scope of any temporary criminal offences of non-compliance when considering any powers of arrest. These will not be indictable offences, so powers of search or entry available following arrest for indictable offences will not arise unless specially created. They will also have to make sure that they fully understand the scope of any powers which are given to them or given to those who are required to work with them, such as the armed forces or such as citizens who are required to assist police. Usually the police can't compel citizens to cooperate positively with them, save to assist in quelling a breach of the peace. But in a sufficiently grave emergency, ministers may consider it necessary to place a duty on citizens to provide certain positive cooperation on pain of prosecution. And as I say, they may grant certain police powers to non-police officers in order to assist them in exercising their duties. Although ministers will not be able to use emergency regulations to require citizens to provide military service, the Civil Contingencies Act does not prevent them from requiring citizens to assist in civil defence endeavours such as food and welfare provision, firefighting, and the maintenance of law and order and the health and well-being of individuals. In relation to law and order, it's conceivable that regulations would enable senior police officers to press responsible citizens into temporary quasi-police service. Members of Her Majesty's forces may be temporarily clothed with police powers and duties during an emergency if police strength is sufficiently weakened during the emergency or demands are too great for their resources. There's a very high likelihood of error in the use of any temporary powers because they're all new and because of the nature of the emergency within which we all operate. And in the discharge of those temporary duties, there are risks that will arise in relation to potential liability. given that there'll be no time for training and briefing in relation to those powers. So great care will be required.